Okay. I guess we're live streaming now on YouTube. All right. So just a couple of reminders I'm required to make here before we begin. Anybody who's in the virtual courtroom who is connected with teams not competing in this round should leave the courtroom at this time. There any use of video recording that anybody's planning to use during this proceeding?
No, Your Honor.
Okay. Thank you.
No, Your Honor, not for the prosecution either.
Okay, great. And just a reminder, there won't be any recesses allowed unless there's an emergency. Any disputes arising out of the competition must be reported in accordance with the competition rules. Compliance with time requirements will be considered in scoring individual performances. And I assume that there are no coaches in the courtroom. If you are a coach, make yourself known. And there are no other team members who are not no team members who aren't participating in this round that are in the courtroom either. Is that right? And do we have timekeepers for this round?
Yes, Your Honor.
Oh, good. Okay. Is that Nori and Miss Boyd or Mr. Boyd? I'm not sure.
Yes, Your Honor. It's Miss Boyd.
Thank you. I don't see you. Okay. Good. So you guys will do the time check in the chat, right?
Correct.
Yes, Your Honor.
Keep us all on track. Thank you very much. Normally we would swear in the team members, the gallery, and the scoring panelists, but for purposes of the virtual competition, I'll just remind everybody that all witnesses, oh, actually, maybe I am supposed to do this. Okay. For purposes of virtual competition, any witnesses who testify will be deemed to be sworn. So I'm going to ask the team members to raise your right hands. Do you promise that the presentation you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition? Okay. And the witnesses, raise your right hands. Do you promise that the testimony you're about to give will faithfully and truthfully conform to your witness statements, that you will not add material facts or opinions which are not contained in the case problem, and that you'll follow the rules and procedures of the mock trial competition? Okay, and gallery members, including teacher and attorney coaches, family members, and friends, please raise your right hands. Do you promise to represent yourselves as positive role models and to behave in a manner that exemplifies ethical and professional sportsmanship during and after this round? I'm assuming all the YouTubers are nodding their heads. Scoring panelists, please raise your right hands. Do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of the mock trial competition?
Yes, Your Honor.
Okay, wonderful. Let's start then with, maybe I should have done this before. I apologize. It's a little different on the virtual. At this time, I would like each side to introduce the participating team members, the attorneys, and the witnesses. So why don't we start with the prosecution?
Yes, Your Honor. Good afternoon, Your Honor, members of the jury, opposing counsel. My name is Angela Wu. I will be conducting the opening statement, conducting the direct examination of Detective Jordan Markowitz, and conducting the cross-examination of Avery Becker.
Good afternoon, Your Honor, members of the jury, opposing counsel. My name is Olga Rafamka, and I will be conducting the direct examination of Kyle Kuzak, and I will be conducting the cross-examination of Professor Blake Van Ellen.
Good afternoon, Your Honor, members of the jury, opposing counsel. My name is Sophie Gebhardt, and I will be conducting the direct examination of Alex Fuentes, conducting the cross-examination of Taylor Perkins, and giving the closing argument. Your Honor, at this time, may we introduce our witnesses?
Yes, please. Thank you.
Good afternoon, Your Honor, members of the jury, opposing counsel. My name is Desta Soma, and I am Detective Jordan Markowitz.
Thank
Good
you.
morning, Your Honor, members of the jury, opposing counsel. My name is Peyton Burnett, and I am Kyle Kuzak.
Good afternoon, Your Honor, members of the jury, opposing counsel. My name is Emma Gamber, and I am Alex Cifuentes.
Thank you. And anybody else for the prosecution
No, Your Honor.
and for the defense?
Good afternoon, Your Honor, members of the jury. My name is Chloe Arroyo, and I will be delivering the opening statement as well as conducting the direct examination of Professor Blake Van Owen, as well as the cross-examination of Kyle Kuzak.
Thank you.
Your Honor, members of the jury, opposing counsel. My name is Jonas Eiches, and today I will be conducting the direct examination of Taylor Perkins and the cross-examination of Jordan Markowitz.
Thank you.
Good afternoon, Your Honor, members of the jury. My name is Lauren Leland. Today, I will be doing the direct examination of Ms. Avery Becker, the cross-examination of Alex Cifuentes, and delivering the closing arguments for the defense. At this time, may our witnesses please introduce themselves?
Yes, please. Thank you.
Good afternoon, Your Honor, members of the jury. My name is Sydney Fawn, and today I will be portraying Professor Blake Van Owen.
Good afternoon, Your Honor, members of the jury, opposing counsel. My name is Miles Wright, and today I will be portraying Taylor Perkins.
Good afternoon, Your Honor, members of the jury. My name is Sarah Banks, and today I will be portraying Avery Becker.
Thank you. Are there any preliminary matters that we need to address? Let's start with the prosecution.
Yes, Your Honor, a few preliminary matters. Your Honor, does the court have the prosecution's trial rosters?
It was my understanding that they were going to post that in the chat. It looks like there's a link in the chat. That may be where they are. But because in this particular case, I was originally scheduled in courtroom 4. Now I'm in courtroom 3. The roster I have was from courtroom 4. So I do not have the roster. Let me check this link.
Yes, Your Honor.
Maybe this is what it is. Yes, I do have it. Here it is.
Your Honor, we ask that the exhibits be shown by screen share as they are being authenticated by the witness and that they're constructively not shown to the jury.
Is there any objection to that request?
No, Your Honor.
Okay, then that's the way we'll proceed with the exhibits.
Your Honor, we ask that the exhibits be deemed to be published to the jury upon being admitted into evidence.
Any objection to that?
No objections, Your Honor.
Okay, we will handle it that way. Thank you. Anything else?
Yes, Your Honor. We ask that the timers are able to communicate using the Zoom chat feature to avoid time discrepancies.
Yes, that will be the way that proceeds. Thank you. Anything further from the prosecution?
Yes, Your Honor. Your Honor, we ask for the identification of the defendant, and when the defendant is identified, we request that the camera be turned on.
So just so I understand, you're wanting the camera to be on when there's an identification of the defendant, but then that the camera be turned back off after the identification?
Yes, Your Honor.
Okay. Any objection, Ms. Leland?
I would like to clarify if opposing counsel is meaning that the first time for the purpose of deciding who the defendant is, identifying them, is that what you mean? Or do you mean every time the defendant is referred to?
Your Honor, opposing counsel, the first time.
No objections to that, Your Honor.
Okay. So if the defendant testifies, while the defendant's testifying, obviously the video will be on. If the defendant is just identified by either side for purposes of an identification, the camera will be turned on and then turned off. Is that correct? Everybody's understanding?
Yes, Your Honor, we have no objection to that.
Okay, great. Anything further, Ms. Wu?
Yes, Your Honor, we asked to reserve any remaining time on the closing argument for rebuttal.
That will be granted. Thank you.
Your Honor, we ask that the stipulated facts be constructively read into the record.
They will be deemed to have been read into the record.
And lastly, Your Honor, we request the same be given to the defense.
You request the same,
be given to the defense.
that the stipulated facts?
No, Your Honor, we request that all the preliminary matters that we went through also be given to the defense.
Oh, I see. Okay, any objection, Ms. Leland?
As much as I would like a rebuttal, I believe we will not extend that preliminary matter to ourselves. However, the rest we would appreciate being extended to our team as well.
Okay, so those will apply to both sides with the exception of the reservation of time for rebuttal. Anything else, Ms. Wu?
No, Your Honor.
Okay. Any preliminary matters the defense would like to raise?
Yes, Your Honor. We would just like to remind the court that pursuant to Rule 7.4 of competition, all witnesses shall have access to all case materials, witness statements, exhibits, etc. throughout the course of trial, but may only refer to them when prompted to do so by an attorney.
Any response to that, Ms. Wu?
No objections, Your Honor.
That's my understanding as well, so that will be the order.
And I believe that's all the preliminary matters we have for the defense, Your Honor.
Okay. Thank you. Ms. Madol, I just got a message. I guess the scoring judges are supposed to have their cameras off.
Oh, look, I'd be happy to turn it off.
So would I. It's not an option. Okay, thank you. All right. Are the parties ready to proceed to trial?
Yes, Your Honor.
Yes, Your Honor.
Okay. We'll start with opening statements from the prosecution.
Yes,
You
Your
may
Honor.
proceed.
May it please the court?
You may proceed.
Your Honor, members of the jury. My name is Angela Wu, and together with my co-counsel, Sophie Gebhardt and Olga Rolchenko, represent the people of the state of Colorado in today's case. Members of the jury, this is a case about bitterness turned brutal. The defendant's bitterness escalated to the point where she brutally murdered Mr. Brackman. That is why we are here today. Now, let's walk through the events of the day of Mr. Brackman's murder. It's Friday, March 6, 2020. Around noon, the defendant breaks in to Mr. Brackman's residence through the back door. After being alerted to the intruder, Mr. Brackman grabs a knife from his kitchen and engages in a struggle with the intruder over that knife. The defendant got a hold of that knife and brutally stabbed Mr. Brackman in the back, leaving him dead. Now, let's rewind. Mr. Brackman was a passionate mock trial coach, and the defendant was a member of that mock trial team. But after continuously disrespecting the mock trial team and starting countless arguments during practice, the defendant's rage finally reached its tipping point. She stormed out of practice and brutally vandalized Mr. Brackman's car, writing Worst Attorney Award with a permanent marker. The defendant was understandably kicked off the mock trial team. And then she sent text messages stating that she was going to break in and trash Mr. Brackman's house. Today, the evidence will show that the defendant did just that. But the defendant went even further and brutally murdered Mr. Brackman. The state has brought the following charges against the defendant: murder in the first degree and second degree burglary. The burden of proof is beyond a reasonable doubt and lies with the prosecution. We will prove each and every element of both crimes. We will show that the defendant killed Mr. Brackman during a burglary. Today, the state will bring forth 3 witnesses. You'll first hear from Detective Jordan Markowitz. Detective Markowitz will testify to who committed the crime and where the crime was committed. Detective Markowitz will testify to the crime scene in detail and the steps of her investigation. Detective Markowitz will testify that after interviewing mock trial member Alex Cifuentes, Detective Markowitz received screenshots of text messages between Ms. Cifuentes and the defendant. In these text messages, the defendant clearly stated she was going to break in and trash Mr. Brackman's house. The defendant's cell tower data places the defendant near the scene of the crime at the time of the murder. Next, you'll hear from investigator Kyle Kuzak, a crime scene reconstructionist. Investigator Kuzak will testify to what happened in the home of Mr. Brackman. Investigator Kuzak will testify that what happened was not a planned burglary. It was a planned burglary gone bad. It was not a planned murder. Investigator Kuzak will testify that after being alerted to the intruder, Mr. Brackman grabbed the knife from his kitchen and engaged in a struggle with the intruder. The intruder got a hold of that knife and brutally stabbed Mr. Brackman in the back. Finally, you'll hear from the defendant's teammate, Alex Cifuentes. Ms. Cifuentes will testify to why the defendant committed these crimes. Ms. Cifuentes will testify that she has been on the same mock trial team as the defendant for 3 years. Ms. Cifuentes will testify to the defendant's character: bitter, impulsive, and arrogant. Ms. Cifuentes will testify that during practice, the defendant's rage boiled over, and the defendant stormed out of practice and vandalized Mr. Brackman's car with a black permanent marker. Ms. Cifuentes will testify that the defendant told her that the defendant was going to break in and trash Mr. Brackman's house. Today, the evidence will show that the defendant did just that, but not only that. The defendant's bitterness and rage escalated to a tipping point where she went even further and brutally murdered Mr. Brackman. Now, after reviewing the evidence presented, the state of Colorado asks you to find the defendant guilty of murder in the first degree and second-degree burglary. Thank you.
Thank you, counsel. Opening statement for the defense?
Yes, Your Honor. They heard hooves and thought zebras. Your Honor, members of the jury, today you'll hear the story of Mackenzie Brackman, a man who was killed in his own home. The prosecution will try to tell you that the person responsible for this murder is none other than Miss Avery Becker, a high school student. Miss Becker was a devoted member of the mock trial team that Mr. Brackman coached. The pair had their occasional differences over various topics, which finally resulted in Miss Becker being permanently removed from her team. Because of this, the prosecution alleges that Miss Becker attempted a burglary that ended in murder. However, as you will see today, the prosecution also failed to analyze the many avenues that the evidence led them down in this case. They instead took the easy route and immediately settled on a single implausible suspect, Miss Becker, who was a high school girl with no motive and an alibi. The prosecution heard hooves and thought zebras, and in doing so, they failed to look into a far more likely candidate, one whose own father was sentenced to life in prison because of Mr. Brackman. The person has no alibi and now has seemingly vanished into thin air. This person is Blair Rollins. In proving our case today, we will call 3 witnesses to the stand. The first is Taylor Perkins, who will testify as to the environment on the mock trial team, detailing that while it sometimes led to small inter-team disagreements, none of it was any reason to commit murder. Furthermore, Mr. Perkins will tell you the entire day of March 6th, the entire day of the murder, he and Miss Becker were together, searching desperately for Miss Becker's lost cell phone. Miss Becker was accounted for, but Mr. Perkins will tell you about someone who was not, about someone who was in fact missing from school that day, Blair Rollins. The second witness you will hear from is Professor Blake Van Owen, who conducted her own investigation of this case, one in which she found time and time again that the prosecution heard hooves and thought zebras. They found no physical or DNA evidence linking to any suspect. It is their idea that the murder of Mr. Brackman was the result of a scuffle between a high school girl and a full-grown male, a scuffle with no signs of a struggle, a scuffle in which Miss Becker did not reveal her identity even in the face of extreme danger, and a scuffle in which no one was cut or hurt over a fight for a knife, up until the point where Miss Becker supposedly wrapped her arm around the adult male victim, pushed her blade through a straight half-inch of bone, and finally killed Mr. Brackman in just one stab. So, of course, confused by this theory, Professor Van Owen reviewed the evidence and came up with another, far more likely series of events, ones in which Mr. Brackman was snuck up upon at his kitchen table, stabbed once effectively from behind, and was left for dead. And this would mean that the murder was not a burglary gone awry, but was in fact the result of a premeditated plan. And Professor Van Owen found only one person capable of such an intention, Blair Rollins. But upon attempting to look further into this new suspect, because the prosecution had failed to do so, even in the light of glaring evidence, Professor Van Owen found that Blair had just disappeared. And finally, you will hear from Ms. Avery Becker herself. While Ms. Becker was proud of her accomplishments on the mock trial team and disappointed in the ultimate choice Mr. Brackman had made, you will hear her say that she would never hurt her coach. Rather, she'd hoped to apologize to him one last time. Avery didn't know where Mr. Brackman lived, and so she certainly never went into or entered near his home. And to put it simply, Avery did not have the means, nor the motive, nor the time to commit a burglary that led to murder. Today, the prosecution bears a burden of proof in this case, which means that they must prove to you beyond a reasonable doubt that Avery Becker broke into Mackenzie Brackman's home and killed him. And as you will see, the prosecution cannot meet this burden. They have no physical or DNA evidence that links to any suspect, let alone Miss Becker. In fact, all they really have to show you are an illogical, implausible series of events, ones in which they failed to investigate a person whose name came up time and time again in their investigation, a person with both the motive and the means to murder the man who allowed their father to be sent to prison before their very eyes, Blair Rollins. At the close of this trial, you will be asked to determine a verdict. We ask that you not hear hooves and think zebras and find Miss Avery Becker not guilty.
Thank you, Ms. Arroyo. Is the prosecution ready to call their first witness?
Yes, Your Honor.
You may proceed.
Your Honor, the state of Colorado calls Detective Jordan Marquis to the stand. Good afternoon, Detective Marquis.
Good afternoon.
Could you please introduce yourself to the jury?
Hi, my name is Detective Jordan Markowitz. I'm a homicide detective for the Denver Police Department.
Why are you here today?
I'm here because I was the detective called to the crime scene, and it was my job to investigate this homicide.
Now, I'd like to discuss your job. How long have you been with the Denver Police Department?
I've been with the department for 13 years and a detective for 7 years.
Do you have specialized experience in any field?
I do. I have specialized training in cell phones, including a certification from the American Academy of Law Enforcement in cell phone technology and forensic data recovery.
How did you earn this certification?
I took a course offered by the Academy, which included intensive training and testing.
Your Honor, pursuant to Rule 702 and 703, I now tender Detective Jordan Marquis as a qualified expert in the fields of crime scene investigation, forensic data recovery, and cell phone technology.
Any objection?
Yes, Your Honor. I object to the forensic data recovery as no foundation has been laid for that field of expertise.
Your response, Ms. Wu?
Your Honor, Detective Marquis has testified that she has a certification from the American Academy of Law Enforcement in forensic data recovery and cell phone technology.
Okay, the objection is overruled. The detective will be recognized as an expert, as tendered. You may proceed.
Now, Detective Marquis, I would like to discuss what happened on March 6, 2020. You say you were called to a crime scene. When did you arrive at the scene?
I responded to a call and arrived at the scene around 2:20. It was a home. Address was 444 South Flower Street.
And what did you first observe at the scene?
When I arrived at the scene, I saw it had already been secured by uniformed officers, and through the open front door, I saw the victim, Mackenzie Brackman, a criminal defense attorney, lying in a pool of blood with a big blood stain on his back and a large knife on the floor beside him. I also observed a ring door camera to the side of the front door.
What did you observe inside the home?
Inside of the kitchen, I observed a knife block on the counter with a large empty slot, as well as a drawer open filled with knives. I also observed a plate on the floor shattered and a chair at the table tipped over. Nearby, I saw blood everywhere, blood drops near the victim, and blood splatter on the wall and even the ceiling.
Ms. Burnett, could you please show Exhibit 3 on the screen? Now, Detective Markowitz, could you please identify Exhibit 3?
Yes, this is a photo of the stab wound.
Could you please identify Exhibit 5?
This is a photo of the knife at the crime scene.
And are each of these fair and accurate representations of the crime scene as you saw it?
They are.
Your Honor, pursuant to Rule 901, the expert has authenticated and identified Exhibits 3 and 5. I now move to enter Exhibit 3 into evidence.
Any objection to Exhibit 3?
No objection, Your Honor.
Exhibit 3 is admitted.
Your Honor, I now move to enter Exhibit 5 into evidence.
Any objection to Exhibit 5?
No objection, Your Honor.
Okay. Exhibit 5 is admitted.
Now, Detective Markowitz, what does Exhibit 3 show?
Exhibit 3 is a clear photo of where Mr. Brackman was fatally stabbed.
What does Exhibit 5 show?
This is a clear photo of the knife at the crime scene, and it's clearly covered in blood.
Ms. Burnett, could you please stop sharing? Now, Detective Markowitz, how did you begin your investigation?
In my experience, cell phones are a great way to figure out a person's life. So my first steps were to download the contents of Mr. Brackman's phone, and I got a hold of his Ring security account, passwords, and data, and was able to view the videos taken on March 6th.
Ms. Burnett, could you please show Exhibit 12 on the screen? Now, Detective Markowitz, could you please identify Exhibit 12?
Yes, this is a video of the intruder at the back door.
And is this a fair and accurate representation of the Ring video as you saw it?
Yes, it is.
Your Honor, pursuant to Rule 901, the expert has authenticated and identified Exhibit 12. I now move to enter Exhibit 12 into evidence.
Any objection to Exhibit 12?
No objection, Your Honor.
Exhibit 12 is admitted.
Now, Detective Markowitz, what does Exhibit 12 show?
Exhibit 12 shows the perpetrator wearing baggy clothes open Mr. Brackman's back door and enter his home.
Ms. Burnett, could you please stop sharing? Now, what does this mean for your investigation?
In my expert opinion, from the Ring video and the evidence at the crime scene, it is clear that the intruder entered Mr. Brackman's home through the back door, and Mr. Brackman had engaged with the intruder, and the intruder had fatally stabbed Mr. Brackman with a knife.
Now, what was the next step in your investigation?
I continued to download the contents of Mr. Brackman's phone, and from there I found many emails and texts related to mock trial. I found out he was a mock trial coach for a local high school.
Did you investigate mock trial?
I did. I wanted to see who Brackman was, so I went to the mock trial team to see if they could tell me anything. I got their contact info.
Who was the first student you contacted?
The first student was Alex Cifuentes. I learned about a text exchange between Ms. Cifuentes and another student named Avery Becker over the phone, and after interviewing Ms. Cifuentes, I received screenshots of the text exchange the following day.
Ms. Burnett, could you please show Exhibit 14 on the screen? Now, Detective Markowitz, could you please identify Exhibit 14?
Yes, this is a photo of the screenshots I received.
And is this a fair and accurate representation of the screenshot as you saw them?
They are, yes.
Your Honor, pursuant to Rule 901, the expert has authenticated and identified Exhibit 14. I now move to enter Exhibit 14 into evidence.
Any objection?
Yes, Your Honor. This exhibit is hearsay, and additionally, it's hearsay within hearsay, as the text messages themselves are out-of-court statements being offered for the truth of the matter asserted. Additionally, the only way this detective knows about these text messages is because of what she heard from Alex Cifuentes.
And your response, Ms. Wu?
Yes, Your Honor. In these text messages, the gray bubbles correspond to the defendant's text messages. The defendant's text messages are not by definition hearsay pursuant to Rule 801(d)(2), as they are statements made by a party opponent. The green text messages shown are Ms. Cifuentes' statements. Those statements are not by definition hearsay pursuant to Rule 801C, as they are not offered for the truth of the matter asserted and are offered to give context to what the defendant was responding to.
Permission to respond, Your Honor.
You may respond. Go ahead.
This detective has no way of knowing whether or not the text messages were actually sent by Avery Becker, as she's never actually seen the phone herself. She's only looking at these screenshots.
Ms. Wu, any response to that?
Yes, Your Honor. The detective is testifying to her knowledge of these screenshots, and the fact that the defendant only has seen the screenshots is something to be challenged on cross-examination and goes to the weight of the evidence presented, not to the admissibility of the evidence.
I agree. I'm going to overrule the objection. Exhibit 14, I believe it is, will be admitted.
Yes, Your Honor. Now, Detective Markowitz, what is shown in Exhibit 14?
From the text exchange, you can see after the defendant was kicked off the mock trial team, Avery Becker said, "I'm going to wait until he's at work, then break in and trash it. That'll show him." He referring to Mr. Brackman and it referring to Brackman's home. After that, I immediately contacted Miss Becker to set up an interview.
Ms. Burnett, could you please stop sharing? Now, Detective Markowitz, did you ever meet with Ms. Becker?
I did not. I was stopped by the attorney. However, I did obtain call detail records for Becker's phone for March 6, 2020.
What are call detail records?
Call detail records record call and text activity from a person's phone. So through them, I'm able to see when the communication was made, the numbers involved in the communication, and most importantly, I'm able to see through which cell tower antenna the communication went through.
What is that called?
That specifically is cell tower data.
Did you do anything with the defendant's cell tower data?
Yes, I collected it, translated it, and then I created a diagram.
Ms. Burnett, could you please show Exhibit 16 on the screen? Detective Markowitz, could you please identify Exhibit 16?
Yes, this is a photo of the diagram I created based off of the defendant's call detail records.
Is this a fair and accurate representation of the diagram that you created?
Yes, it is.
Your Honor, pursuant to Rule 901, the expert has authenticated and identified Exhibit 16. I now move to enter Exhibit 16 into evidence.
Any objection?
Yes, Your Honor. This exhibit contains a dotted line on it, which is hearsay, as it is an out-of-court statement being offered for the truth of the matter asserted.
Your response, Ms. Wu?
Yes, Your Honor. The dotted line is actually not by definition hearsay, pursuant to Rule 801C. It is not offered for the truth of the matter asserted to show that the defendant actually traveled along those lines. It is offered to show a possibility of what the defendant might have done.
And who placed the dotted lines?
Your Honor, Detective Markowitz placed those dotted lines.
Okay. I'm going to overrule the objection. The exhibit will be admitted.
Yes, Your Honor.
Detective Markowitz, what does Exhibit 16 show?
This exhibit shows the defendant's house, Brackman's house, and the cell towers the defendant's phone was connecting to throughout a 35-minute period.
Ms. Manette, could you please stop sharing? Detective Markowitz, who is the defendant?
The defendant is Avery Becker.
Is the defendant here today?
They are, yes.
Would the defendant please turn on their camera?
That is the defendant, Miss Avery Becker.
Thank you. Now, what is your expert opinion given the text messages?
In my expert opinion, based upon the text messages, Avery Becker planned to trash Brackman's house in retaliation for being kicked off the mock trial team.
What is your expert opinion given the defendant's cell tower data?
In my expert opinion, based upon the collection of Becker's call detail records and the cell tower data, Avery Becker, or the defendant, was near Mr. Brackman's house, the scene of the crime, at the time of the brutal murder.
No further questions at this time, Your Honor.
Thank you, counsel. Cross-examination?
Yes, Your Honor. Detective Markowitz, let's talk about the events on March 6th. The victim in today's case, Mr. Brackman, was a grown man, correct?
That is true. I believe he was 54.
And the defendant in this case, Miss Avery Becker, is Miss Avery Becker, correct?
That is correct.
And Mrs. Becker was only a high schooler at the time of the murder, wasn't she?
Avery Becker was a high school.
Your Honor, I object on relevance to this question.
Your response, counsel?
Your Honor, this evidence is relevant because it shows that the detective's theory doesn't make much sense.
Could you specify a little bit further?
As the detective believes that this high school girl was somehow able to overpower a grown man who was alerted to an intruder and armed himself with a large knife, this high school girl, unarmed, was able to end up killing him.
I'll overrule the objection. You may proceed.
You believe that Mr. Brackman was alerted to the presence of an intruder by his ring security system, correct?
Yes, that is true.
After being armed by this ring security system, he then armed himself with a large knife from the kitchen, didn't he?
Yes, that is also correct.
Armed with this large knife from the kitchen, he confronted the intruder, correct?
Yes.
You assume that the intruder, Miss Becker, somehow got control of this large knife from the victim, don't you?
It is not as an assumption as it is my expert opinion based upon the evidence at the crime scene.
Miss Becker was able to do all this without sustaining any injuries to herself?
I am unsure if Becker received injuries from this struggle.
Okay. Now let's talk about your interview with Alex Cifuentes. The first person you contacted in this case was Alex Cifuentes, right?
That is true.
And Cifuentes shockingly gave you the biggest break of the case.
They did. It doesn't happen very often.
It doesn't happen very often. Miss Cifuentes alleged that Miss Becker had a plan to vandalize Mr. Brackman's house, correct?
Ms. Fuentes provided me with screenshots of text messages that supported that, yes.
You asked to see Miss Cifuentes' phone for proof, correct?
That is correct.
However, Miss Cifuentes didn't bring their phone to the interview, did they?
Ms. Fuentes did not bring her phone to the interview.
You downloaded the contents of Mr. Brackman's phone, correct?
That is correct.
You obtained cell tower records of Miss Becker's phone, correct?
That is correct.
As well as cell tower records.
Yes.
But you didn't do any of this for Miss Cifuentes' phone, did you?
I did not, as I had met with Ms. Fuentes.
Instead, you asked for screenshots of these text messages.
I did, as Ms. Fuentes had forgotten her phone for the interview.
Ms. Cifuentes sent you these screenshots a full day after your interview, didn't she?
That is when I received them.
And couldn't these screenshots easily have been faked after a full day?
Objection, Your Honor. The question calls for speculation.
Your response, counsel?
Your Honor, this question falls into the witness's field of expertise.
Okay, maybe you could lay just a little bit more foundation then.
You are an expert in cell phone analysis, correct?
I am, yes.
And after a full day, these screenshots easily could have been faked, couldn't they?
Any text could be faked. However, in this case, I met with Mr. Fuentes the previous day, and based upon my interview with Mr. Fuentes, and I received the screenshots the following day, they were not.
But was that a yes? These screenshots easily could have been faked a full day after the interview?
These screenshots, based upon my investigation, were not.
But you still didn't think that a piece of information as important as this was worth verifying through downloading the contents or checking the cell tower records, did you?
I did not verify in that matter. I verified by my interview with Mr. Fuentes.
Thank you. Let's move on. I'm directing your attention to what has been entered into evidence as Exhibit 16. Exhibit 16 is a diagram that you created, correct?
Yes,
In the top left-hand corner, you included Blair Rollins' house in this diagram, didn't you?
there is a marked location called Blair or Rollins' house. Yes,
Blair Rollins' father was a client of the victim, wasn't he?
he was an ex-client of Mackenzie Brackman. Yes,
Blair Rollins' father, Mr. Brackman's client, was sentenced to life in prison, correct?
to my understanding, yes.
You said that the fact that Brackman did criminal defense work raised the specter that this could be the work of a disgruntled ex-client, correct?
Objection, Your Honor. Improper impeachment.
Could you expand on that, Ms. Wu?
Yes, Your Honor. Counsel's question was, you said with a sentence following that. I believe that is, Your Honor, that is improper impeachment.
Mr. Zeitchus,
That's correct.
your response?
Your Honor, this wasn't for impeachment purposes. I was just asking a question.
Okay, maybe you can rephrase the question, counsel.
Yes, Your Honor. The fact that Mr. Brackman did criminal defense work raised the specter that this could be the work of a disgruntled ex-client, correct?
That was a theory before I began my investigation.
But it was, in your words, something to consider.
Of course, as there is always different paths for a case, that was something to consider.
However, you never actually interviewed Blair Rollins, did you?
I did not, as that was not called for in my investigation.
So you don't know where Blair Rollins was on the day of the murder?
I do not know where Blair Rollins was.
You also don't know where Blair Rollins is today, do you?
I don't believe anyone knows where Blair Rollins is today.
You also don't know if Blair Rollins has cuts on his hands and forearms that would be consistent with your knife fight theory, do you?
I have not looked at Blair Rollins to see if there are cuts and bruises on him or her.
But you still understood that Blair Rollins was important enough to include on this diagram, didn't you?
I did. As I had begun my investigation, I viewed possible suspects.
Because Blair Rollins is a suspect in today's case, correct?
Blair Rollins was a suspect in this case. However, as I went further.
Thank you. No further questions.
Any redirect, Ms. Wu?
Yes, Your Honor, briefly.
Go ahead.
Now, Detective Markowitz, are the screenshots you received from Ms. Cifuentes accurate?
They are.
And how do you know that they are authentic?
In my 13 years of experience, I've learned to read people. And during my interview with Ms. Cifuentes, I learned Ms. Cifuentes was reliable.
Now, why didn't you investigate further into Blair Rollins?
My investigation, as I had followed the evidence provided for me, did not call for the collection of investigating further into Blair Rollins.
Thank you, Your Honor. No further questions at this time.
Anything further of this witness?
No, Your Honor.
No, Your Honor.
Okay, the witness is excused. Prosecution may call your next witness.
Your Honor, before I do so, the prosecution would like to call for a brief time check.
Okay, can we get a time check?
You have 14 minutes and 48 seconds left.
Thank you. Your Honor, may I proceed?
Yes, you may proceed.
The state of Colorado calls Kyle Kuzak as its next witness. Good afternoon, Ms. Kuzak. Could you introduce yourself to the jury?
Hello, my name is Kyle Kuzak.
Ms. Kuzak, why are you here today?
I'm here today to give my expert opinion on the reconstruction of the crime scene based on evidence collected and offer my conclusion about what happened in the home on the day the victim was murdered.
What is your occupation?
I'm a crime scene reconstruction investigator for the Colorado Bureau of Investigation.
What do you do as a crime scene reconstructionist?
I specialize in the analyzation and organization of crime scenes. So I take all the evidence on a scene and create a visual picture of what happened.
Could you tell the jury about your experience in this field?
I've been a CSR for 19 years, so I've analyzed all kinds of crime scenes.
Your Honor, pursuant to Rule 702, testimony by experts, and 703, basis of experts' opinion testimony, I am tendering Ms. Kyle Kuzak as a qualified expert witness in the fields of analysis and reconstruction of crime scenes.
Any objection, Mr. Arroyo?
No objection, Your Honor.
Okay, thank you. The witness will be recognized as an expert in the areas tendered.
Yes, Your Honor. Ms. Kuzak, can you tell the jury about your CSR process?
Sure. I begin with two main principles. So first, I assume that every single case is going to trial. And second, from day one, I walk into a crime scene with a mindset of future reconstruction. These ensure an accurate and efficient flow of my crime scene reconstruction work, which I then approach in 5 parts.
Could you list those 5 parts for the jury, Ms. Kuzak?
First is recognition and documentation. Second is collection of evidence. Third is evaluation of evidence. Fourth is hypothesis and testing. And finally, the reconstruction.
Could you tell the jury how you gathered the evidence that you will discuss today?
I visited the scene of the crime, and I also analyzed some evidence from the crime scene post-processing at the crime lab.
And what evidence of importance did you gather?
Evidence of importance to my latter conclusions were what are marked as exhibits 6, 8, 9, 18, and the blood splatter on the scene.
Would you be able to recognize all of these documents if I showed them to you?
Yes, I would.
Ms. Soma, would you bring up exhibit 9? Ms. Kuzak, would you identify exhibit 9?
Yes. Exhibit 9 is the image of the broken plate in the victim's kitchen.
Ms. Soma, would you bring up exhibit 18? Ms. Kuzak, would you identify exhibit 18?
Yes. Exhibit 18 is the photo of the scuff marks immediately inside the victim's back door.
Could you identify exhibit 6 for the jury?
Yes. Exhibit 6 is the photo that I took of the knife at the crime processing lab.
And finally, could you identify exhibit 8?
Yes. Exhibit 8 is the photo of the knife block, clearly missing a knife.
And are these fair and accurate representations of all these exhibits?
Yes, they are.
Your Honor, pursuant to Rule 901, the witness has authenticated and identified exhibits 9, 18, 6, and 8. Your Honor, I move to admit exhibit 9 into evidence.
Any objection to exhibit 9?
No, Your Honor.
9 is admitted.
Your Honor, I move to admit exhibit 18 into evidence.
Objection to exhibit 18?
No objection, Your Honor.
18 is admitted.
Your Honor, I move to admit exhibit 6 into evidence.
Any objection to exhibit 6?
Yes, Your Honor. I'd like to object under Rule 403 as this picture is more prejudicial than probative. It's covered in gore, which serves to inflame the passions of the jury.
Your response, counsel?
Yes, Your Honor. This image is not more prejudicial than probative, as it is of great value to the latter conclusions of Ms. Kuzak. Additionally, it is the murder weapon, and so it is incredibly valuable that the jury is able to see every aspect of what happened at the scene.
All right, the objection's overruled. The exhibit's admitted.
And finally, Your Honor, I move to admit exhibit 8 into evidence.
Any objection to exhibit 8?
No objection, Your Honor.
8 is admitted.
Ms. Kuzak, why was exhibit 9 significant in your analysis?
Exhibit 9 was the photo of the broken plate. This was the first sign of the struggle that I observed on the scene.
Could you explain exhibit 18 to the jury?
Exhibit 18 is the photo of the scuff marks. The scuff marks, when combined with the image of the broken plate and the blood splatter on the scene, indicated the path of the struggle.
What were the conclusions you drew from exhibit 8?
Exhibit 8 is clearly missing a slot for a chef's knife, which was the same type of knife that was eventually identified as the murder weapon.
And how was this weapon introduced to the scene?
In my expert opinion, the victim frantically searched through his kitchen before eventually deciding upon the larger chef's knife from the block to defend himself.
Now let's discuss the struggle that you've talked about. What was its progression?
The struggle began immediately when the intruder entered through the back door. In my expert opinion, the intruder and victim were in very close proximity when the intruder eventually got a hold of the knife.
What happened next?
Somewhere between the kitchen table and the front door, the intruder did get a hold of the knife and was being constrained by the victim in a sort of bear hug when the intruder reached over and stabbed the victim in his upper back.
Now, why was the blood spots important in your analysis?
There was a series of small blood droplets leading from the kitchen table to the front door. The blood droplets were more than sufficient to show what happened, in my expert opinion.
Next, let's discuss Exhibit 6. What is shown in it?
Exhibit 6 is the photo that I took of the knife at the crime lab. This has measurements on the bottom, and so that you can see that the knife blade measures 7.5 inches with a maximum width of 2.5 inches.
What's the significance of this?
This is the same type and size of knife that would fit in the knife block.
Where was that knife eventually found?
The murder weapon was eventually found behind the victim's body inside the home.
Ms. Kuzak, what is your expert opinion on what occurred on the day Mackenzie Brackman was murdered?
My expert conclusion is that this was a planned burglary gone bad that led to the tragic and brutal murder of the victim with the very knife that he picked up to defend himself.
Thank you, Ms. Kuzak. No further questions at this time, Your Honor.
Thank you. Cross-examination?
Yes, Your Honor. Hello, Ms. Kuzak.
Hello.
So am I understanding your testimony correctly that you believe a high school girl showed up in costume at Mr. Brackman's home intending to burglarize it?
Yes, that was the most likely conclusion based off of the evidence at the scene.
And then he met her at the door brandishing a 12-inch long knife.
Yes, that was the most likely conclusion.
And then he and Miss Becker engaged in some sort of face-to-face struggle.
Yes, all of the evidence on the scene really led me to believe that there was some sort of struggle.
And right, in that struggle, then Miss Becker wrestled that knife away from him.
Yes, eventually the intruder did get a hold of the knife.
And she got close enough to bear hug him.
No, I believe that's not correct.
So you're saying that Miss Becker did not bear hug Mr. Brackman?
No.
Is that your statement in court today?
The intruder was being constrained by the victim in a bear hug.
All right, and so in that bear hug, the two spun all the way from the back door to the kitchen, where Miss Becker then drove that knife through Mr. Brackman's shoulder blade.
Somewhere between the kitchen table and the front door, the fatal injury occurred.
All right, and so before we talk about any other evidence, you would agree that the state has no evidence that Mr. Brackman suffered any injuries beyond that single stab wound in his back.
That was the conclusion that we were led to, yes.
No cuts to his hands or arms?
That was not apparent in any of the crime scene photos, nor in the body.
And there was no evidence of an injury to Miss Becker?
We didn't necessarily observe Miss Becker for injuries.
All right, and so the knife in this case was about 12 inches long, right?
Yes, with the blade measuring 7.5 inches.
So then it would have been about this length.
Objection, Your Honor. Cumulative.
Your response, Ms. Arroyo?
Your Honor, I'm just asking the expert as to how long the knife was.
Response, Your Honor.
Go ahead.
The witness has already testified multiple times as to the size of the knife, and this is merely a repetition of something that's already been brought up.
I think that Ms. Arroyo is entitled to explore it on cross-examination. The objection's overruled.
All right, so to re-ask that, the blade would have extended to here and the handle would have been here, right?
That's an approximate size, yes.
All right, so then let's say, like I said, the handle's here and my hand's on the handle. How would Miss Becker have gotten that knife away from somebody who was holding the handle?
I can't necessarily say, I wasn't in the home, but I do know that was my conclusion.
So to put that in perspective, could she get a highlighter away from Mr. Brackman without getting any ink marks on her body, or in that case, cuts?
I can't say I wasn't there, but potentially, yes.
All right, so now let's switch roles and say I'm the assailant and I've somehow wrestled the knife away from you without either of us getting hurt. And then I try to bring that.
Speculation.
Response?
Your Honor, under Rule 702, unlikely witnesses, experts may testify as to hypotheticals.
The objection's overruled. Go ahead.
All right, so I'm bringing that knife around your body. Wouldn't you agree that you would likely try to block it and defend yourself?
That was possible. However, that wasn't what happened in this case.
So Mr. Brackman just kept his arms at his sides and let Miss Becker position that knife at his back?
I don't necessarily know what he did, but that was the conclusion. That was the most likely conclusion.
All right, so you would agree that the adult human scapula is approximately ½ an inch thick of solid bone, right?
Probably.
So Miss Becker pushed hard enough to stab that entire chef's knife through that much bone.
Yes, that's what happened.
And the blade sunk all the way in, all the way to the bolster of the knife.
Yes.
All right, and so Miss Becker was strong enough to completely overwhelm Mr. Brackman in order to do so.
Yes, that's correct.
All right, so now I'd like to talk a little bit about the evidence that you don't have. You like to be extremely thorough in your work, do you not?
I do. I would love to be as thorough as possible.
And so you looked at all possible points of the case.
Yes.
And so to continue your story of events, you believe that the decedent was warned of an intruder from their ring security system.
It's very unlikely that the victim was surprised by the intruder.
But isn't it true that it's not certain that the security system's alerts were even on?
Objection. Speculation.
Your response, Mr. Royal?
Your Honor, under Rule 702, experts may testify as to hypotheticals, and this does fall within Ms. Kuzak's expertise.
Response, Your Honor.
Go ahead.
Ms. Kuzak is not an expert in cell data or cell towers, or in that manner, general cell phone matters. And this question will ask her for speculation as to the status of notifications, which is outside her scope of expertise.
Your Honor, may I respond?
Go ahead.
I'm asking as to whether or not the decedent's ring system alert system was on, which goes directly in with her entire case theory, which is her job as an expert in crime scene reconstruction.
Okay, Ms. Arroyo, could you lay some additional foundation as to this witness's knowledge about the ring notifications?
Yes, Your Honor. So Ms. Kuzak, you looked at all possible points of this case.
Yes, I looked at all of the evidence that I had available to me.
And that includes the ring security system.
Yes, I did observe those videos.
And you believe that the decedent was warned of an intruder from their ring security system?
Yes, that was the most likely conclusion, considering that the ring security video system was created to alert people to people outside of their homes.
But looking at that system, you cannot be 100% certain that the alerts were on.
There are other possibilities of the way that the victim could have heard the intruder. However, it's more likely that he would have heard the ring notifications.
All right, so considering the slight chance that Mr. Brackman did not, could that mean that perhaps the perpetrator could have snuck up on Mr. Brackman instead of engaging in combat with him?
That's not a very likely conclusion.
All right, and so also going along with your story further, you also found no DNA evidence of the perpetrator, did you?
In a struggle that is of such a short duration, there is not very often there is very much physical evidence of this physical DNA.
So nothing from that face-to-face knife fight, like the wild one that you described, happened?
No, that's unlikely that it would happen at all.
All right, and so you also found no fingerprints.
Like I said, the intruder was wearing gloves in the videos, so it would make sense that there would not be fingerprints.
Right. So besides no DNA evidence, you also found no physical evidence of any specific perpetrator.
No, however, the evidence at the scene that we did have led us to the most likely conclusion.
All right, but you did admit that you would have preferred to have more physical evidence on the scene.
That's true in every case. We can't control how much evidence we have, but we can always control what we do with it. And we did what we could do with this, and we found the most likely conclusion.
All right, and so taking into account your expertise in crime scene reconstruction with events, I'd like to go over a potentially different set of events with you. Could all of this evidence indicate that perhaps Mr. Brackman was sitting at his table when an intruder snuck up from behind him, intending to kill him before suddenly stabbing him in the back?
I'd say that's quite the leap, although I guess someone could get there if they tried hard enough.
All right, and so then taking your theory into account and looking at that, we would have to figure out how a high school girl wrestled a knife away from an adult male, locked him in combat throughout the house, somehow got the knife around to his back, and was strong enough to push it through that straight half-inch of bone.
Yes, adrenaline can do crazy things to people, and that is not an unlikely conclusion at all by any means.
Thank you, Your Honor. No further questions.
Thank you, counsel. Any redirect?
Yes, Your Honor, briefly.
Go ahead.
Ms. Kuzak, is it typical for there not to be DNA evidence left at a scene?
In a crime like this, yes, because the victim and intruder were only engaged for such a short period of time, there would not be very much physical evidence at the scene.
Now, how would it be possible for, as counsel put it, a teenage girl to have wrestled this knife away from Mr. Brackman?
This is the most likely conclusion. The two were engaged, and adrenaline can do crazy things to people. Plus, Mr. Brackman was an older man, so it's not very unlikely that the intruder could have gotten the knife away from the victim and stabbed him.
Now, why is it not of incredibly valuable importance that every single piece of evidence was not placed?
So think about it like this. If you're putting together a puzzle and you're missing 5 pieces, you can still look at the puzzle and you know what it is. And in this case, that puzzle showed that this was a planned burglary gone bad.
Thank you, Your Honor. No further questions.
Anything further for this witness?
No, Your Honor.
Okay. The prosecution may call their next witness.
Your Honor, at this time, I would like to request a brief time check.
Okay, go ahead.
You have 6 minutes and 58 seconds left.
Thank you. Your Honor, at this time, the prosecution calls its third and final witness, Alex Cifuentes, to the stand.
Okay. You may proceed when you're ready.
Thank you, Your Honor. Good afternoon, Ms. Cifuentes. Could you please introduce yourself to the jury?
Good afternoon. My name is Alex Fuentes, and I am a senior at Colorado High School.
And why are you here today?
I'm here today because I personally know Avery Becker, and from my experience, when she says she's going to do something, she always does it, no matter the consequences.
Let's talk about mock trial. How do you know the defendant from mock trial?
Well, me and Avery have been on the same team for many years, and Coach Brackman was our coach, and we've all been in practices together.
What was the defendant like as a teammate?
Well, Avery was an amazing mock trial member. She really knew how to just make anything up on the spot and make it 100% believable. It was like she could fool the jury into being, I don't know, putty in her hands.
Objection, Your Honor. Confuses the jury, confuses the facts at issue 403.
Your response?
Your Honor, this is not meant to confuse the jury with the facts at issue in this case. This is simply meant to provide insight into the relationship between Ms. Cifuentes and Ms. Becker as they were teammates on this mock trial team.
Okay. I'm going to overrule the objection. You may proceed.
Did you finish your answer?
I did.
All right, I will move on then. Did anything stand out to you between the defendant and Mr. Brackman?
Well, it was kind of hard to miss, honestly. They would argue all the time during practice. It was just constant.
Let's talk about those arguments you observed. Who instigated these arguments?
Well, from what I observed in practice, it was almost always arguments that were instigated by Avery doing something.
Was there any argument in particular that sticks out to you?
Yeah, well, there's this one argument where Coach and Avery, they were going at it head to head, and it reached this like total tipping point.
What happened next?
Avery stormed out of practice, and she had something in her hand that was a permanent marker.
Then what happened?
She wrote Worst Attorney Award on Coach Brackman's Porsche, and it wouldn't come off.
Let's talk about what happened after Mr. Brackman's car was vandalized by the defendant. How was the team affected by this?
Well, unfortunately, we lost Avery as a team member. She even attempted to excuse the vandalization by saying it was a dry erase marker. But really, Sharpies and dry erase markers don't look anything.
Objection, Your Honor, speculation.
Your response, Ms. Gebhardt?
Your Honor, this is not speculation, as it is what the witness rationally perceived, and it is common sense to her, as the witness was in the classroom when this incident occurred, and is based off her perception.
Objections overruled. You may proceed.
Did you finish your answer?
Yes, I did.
Now, what happened next?
Well, Avery texted me. She was really just pleading if I could get Coach Brackman to let her back on.
Did you do that?
I, of course, tried. I made the most impassioned plea I could.
Were you successful in getting her back on the team?
No matter how hard I tried, Coach Brackman was really wasn't budging. I think it was just everything that led up to this point, to be honest.
Let's talk about what the defendant texted you after you said this. Ms. Burnett, would you please screen share Exhibit 14? Ms. Fuentes, could you please tell us what the green messages mean?
Well, the green messages is what I sent in response to Avery.
Could you tell us what the gray messages mean?
The gray messages is what Avery had sent me.
What happened next?
Well, as you can see, Avery texted me and she said she was going to trash Brackman's home while he was at work and how that'll show him.
What did you say in response to that?
I told her it wasn't a very good idea. I mean, vandalizing someone's house just isn't some prank, and I thought it would convince her otherwise.
Ms. Burnett, would you please stop screen sharing? Then what happened?
Well, I later found out that Coach Brackman's house was broken into and trashed, and that my coach was murdered.
Thank you. Your Honor, no further questions at this time.
Cross-examination, Ms. Leland?
Yes, Your Honor. Hi, Ms. Fuentes.
Hello.
I'd like to start off by talking a little bit about mock trial. You did mock trial at Colorado High School, correct?
Yeah, I've been on the mock trial team for about 3 years.
And you really loved being on that team, didn't you?
It was a super fun activity for me, and it just really was what I love to do.
And you cared a lot about your team, didn't you?
My team was like my best friends. We all supported each other, and I cared about every person on the team.
But one of your teammates, Avery Becker, she didn't care about mock trial as much as you did she?
Well, from what I observed, she just didn't put in as much effort, but she did have this amazing talent.
Right, but she would come to practices late and she would show up to competitions unprepared, didn't she?
Yes, and it really did stress the whole team out, which I felt bad for the rest of the team.
And despite the fact that she was so underprepared, as you mentioned, she was actually quite successful, correct?
Oh my gosh, she was so successful. Her words just lulled the jury into whatever she wanted.
Yes, but the fact that she was so successful without being so prepared as you were, that irked you, didn't it?
I did see it. I did see it as a bit of a bummer that she didn't use her full potential.
In fact, you actually called it a slap in the face. Isn't that right?
It was a bummer.
A slap in the face, nonetheless, correct?
You heard what I said.
So is that a yes to my question?
Objection, Your Honor, asked and answered.
Your response, Ms. Leland?
Her response to my question was, you heard what I said.
Your Honor,
agree.
may I
Objection.
respond, Your Honor?
Go ahead.
Your Honor, the witness testified that yes, it was a bummer.
I'm not sure the witnesses completely answered the question that was posed, so I will overrule the objection.
So, Ms. Fuentes, you thought that Miss Becker, the way that she was treated, that was a slap in the face to you, wasn't it?
I mean, I have to say mock trial isn't always fair, but yes.
Now, I'd like to talk a little bit about your involvement in today's case. The police contacted you about the case, correct?
It was actually one of the worst phone calls I've ever gotten in my life. It was the phone call where I found out that my coach was murdered.
And you told them that you had evidence against Avery Becker, didn't you?
Well, I realized that what the detective was describing was exactly what I was sent from Avery, and I had to tell someone.
Let's talk about that evidence that you gave to the police. You gave the police a screenshot of some text messages, correct?
I showed them what was on my phone, yes.
But you didn't show them your actual phone, did you? You showed them screenshots instead.
Well, as screenshots are exactly what is on the phone, yes, I did.
Now, the police never asked you to bring your phone into the station, did they?
Sadly, I was actually asked to bring my phone in, and I put it on the charger for the night before to bring it in.
And they never said that you needed to bring it back?
Bring it back where? Back to my house?
No, they never told you after you left your phone that day. They never told you again that you needed to bring your phone to them, did they?
We did offer, but they said that the screenshots was all that was necessary after everything that I had told them.
Right, so they didn't have you authenticate these messages in any way, did they?
Well, as screenshots are exactly what is on my phone, they're pretty authentic.
But they didn't ask you to use an authentication program to authenticate the messages.
Objection, Your Honor, asked and answered.
Your response, Ms. Leland?
Your Honor, I'm asking the witness whether or not she was asked to use an authentication program to authenticate these text messages, which is not a question I've asked before.
Overruled. Go ahead.
So were you asked to use an authentication program to authenticate the messages?
Well, I'm not very good with phones. I don't even know what an authentication program is, let alone how to use it.
And the police never taught you that, did they?
Well, this is outside of my statement, so I can answer if you want me to.
I'd like you to answer. So the police, they didn't ask you. They did not teach you how to do that, did they?
Well, as I'm not sure if there's such a thing as an authentication, I have no idea what you're talking about.
Not even a free authentication app.
There's an app for authentication?
Yes, there is, in fact.
Wow.
Anyway, I would just like to be clear here. The police did not make you do any of that, did they?
Well, as I had told them exactly what is in the screenshots, they told me it was unnecessary.
And so you didn't authenticate them in any way?
As it is exactly what is in my phone, I think that's authentic.
So in terms of whether it's authentic, though, because it was not authenticated in any way, we're just going to have to take your word for it, aren't we?
Well, because I'm not a lawyer, I can't tell you exactly what authentication means or what the word definition is, so I'm not sure.
But that's a yes, you're the only person that has seen those actual messages.
Well, and my parents have seen it.
But you're the only one in court today.
Well, Avery sent me the messages, so I would assume she's seen it.
And if Avery Becker received those texts, you think she would tell us that?
Well, obviously she does like to lie, so she hasn't told us before.
No further questions, Your Honor.
Any redirect?
Yes, Your Honor, briefly.
Go ahead.
Ms. Fuentes, could you tell us more about what happened when you went into the interview and when you gave the screenshots to Detective Markowitz?
Well, I went into the interview and I really was trying to make up for the fact that I didn't convince Avery to not murder my coach. So I told the detective every little piece of information that she needed and that I knew.
Thank you. No further questions, Your Honor.
Thank you. Any other witnesses for the prosecution?
No, Your Honor. At this time, we would just like to make sure exhibits 3, 5, 6, 9, 8, 12, 18 and 16 have been admitted.
That's what my records show. Is there any objection from the defense?
Your Honor, Exhibit 14 was also entered.
As well as 14, thank you.
And Exhibit 14. Those exhibits just identified have been admitted to the record.
Thank you,
Anything
Your
else
Honor.
from the prosecution?
No, Your Honor, the prosecution rests.
All right, the defense may call its first witness.
Yes, Your Honor, the defense would like to call Professor Blake Van Owen to the stand. Hello, Professor Van Owen. Please introduce yourself to the jury.
Hello, my name is Professor Blake Van Owen.
Why are you here today?
I have been hired as a private investigator on behalf of the defense.
And what is your current occupation?
I am a professor at the University of Colorado, Denver, in the fields of police practices and criminal justice, and I am also a private investigator.
Were you always in these positions?
No, I actually started my career in the Aurora Police Department and worked there for about 9 months before I left after I became increasingly disillusioned with their tactics after I had an incident.
And after that, what did you do?
I went back to school to get my master's degree in criminal justice, and I had a series of job stints before I became this college professor, private investigator, and also expert witness.
So what is your experience with testifying in court?
I have testified on over 100 cases as an expert witness in the U.S. district courts and state courts across the country, including those of Colorado. And I regularly testify in crime scene reconstruction, cell tower analysis, and general police investigation, to name just a few.
Your Honor, pursuant to Rule 702, I move to enter Professor Blake Van Owen as an expert in private investigation, police practice, and cell tower analysis.
Any objection?
Yes, Your Honor. Permission to conduct a brief voir dire?
Yes, you may. Go ahead.
Professor Van Owen, I'll begin with asking you a couple questions about your job. Isn't it true you've never completed any official training as a crime scene reconstructionist?
No, but I have extensive experience in testifying on the matter.
Isn't it true you've only been admitted as an expert in cell tower reconstruction analysis 5 times?
Yes, but I've testified on over 100 cases.
And you have no training in cell tower analysis, correct?
No, but like you've said, I've testified on it as an expert witness 5 times.
Your Honor, while I do not object to Professor Van Owen being entered as an expert in general police investigation tactics and crime scene reconstruction, I do object to his inclusion as an expert in cell tower analysis, as he has lack of both training and experience in the subject.
Your response, Ms. Arroyo?
Your Honor, Rule 702 indicates that an expert witness may be qualified by knowledge, skill, experience, training, or education. And Professor Van Owen has plenty of experience, knowledge, and skill as seen by her previous enterings as an expert as such, and her copious amounts of experience.
Why don't you lay a little bit more foundation about her testimony concerning the areas that counsel has objected to?
Certainly. So Professor Van Owen, how often have you testified on crimes or cell tower analysis?
But about 5 times, and each case I put a copious amount of work into. And in general, I've testified over 100 times, and in each case, I use my expertise on all my different fields, including cell tower analysis.
Your Honor, pursuant to Rule 702, I move to enter Professor Van Owen as an expert in cell tower analysis, as well as private investigation and police practices.
Okay, I'm going to recognize the witness as an expert over the objection. You may proceed.
All right, so now I'd like to talk a little bit about the case at hand. How did you become involved in the case?
I was hired as a private investigator on behalf of the defendant.
And what did you do for your investigation?
I reviewed all the materials in this case, including the police reports, the cell tower records, the crime scene reconstruction, and then I conducted my own investigation on the areas that I felt had been overlooked by the police.
And so, looking at those police reports, do you believe that the evidence and analysis described by Ms. Cusack and Detective Markowitz supports their conclusions?
No, not in the slightest. It's clear to me that the police investigation was rushed and it overlooked a lot of important...
Your Honor, speculation. The witness cannot know the timing of the investigation as she was not there.
Your response, Ms. Arroyo?
Your Honor, as an expert and someone who looked into this case professionally, Professor Van Owen overviewed the timeline as well as all of the materials involved in this case. And so she has a very good grasp of what went down in this investigation.
Perhaps you can have the witness testify about her knowledge about the timeline then, since that is the specific objection.
All right. So Professor Van Owen, looking at the police reports or the reports done by Ms. Cusack, did you think that her story, her theory lined up?
No, the first thing I noticed was that Detective Markowitz, after her very first witness interview, came to her prime suspect. Her very first interview was Alex Cifuentes, and that gave her her suspect. It seems clear to me that the police heard hooves, and instead of coming to the logical conclusion of horses, they made a wild assumption that it was zebras, that it was Avery Becker.
And what else about Ms. Cusack's theory just didn't line up?
There were multiple things. First of all, the way in which Mr. Brackman was stabbed, the scuffle that the prosecution alleges ensued, and the knife. Those are all things that didn't make sense.
And what about Detective Markowitz's theory didn't line up?
The cell tower records.
Now, let the record reflect that I am showing the witness what has been previously marked as Exhibit 15. Do you recognize this document?
I do. It's a diagram of the cell tower data collected by Detective Markowitz.
And is it a true and accurate depiction of the cell tower analysis at that time?
Yes.
Your Honor, I move to enter Exhibit 15 into evidence.
Any objection?
Yes, Your Honor, this exhibit is cumulative as it is essentially a clear, almost duplicate of Exhibit 16, which has already been entered into evidence.
Looks like there's some differences in this exhibit. Ms. Arroyo, what's your response?
Your Honor, I would be more than happy to use Exhibit 16.
Okay, so are you withdrawing the request to have Exhibit 15 admitted?
Well, I do believe that Exhibit 15 may be entered as an exhibit because the professor has knowledge of this. She used this in her investigation, and it does have differences from Exhibit 16, but if necessary, I can use Exhibit 16.
Okay, I'm going to go ahead and admit Exhibit 15 over the objection. You may proceed.
All right, so Professor, looking at this, can you explain a little bit of your thought process behind this exhibit?
Yeah, so if you look at each cell tower, you can see that the shaded red areas is an arc of about 120 degrees. And so if you look at it, this ends up covering about 37.7 square miles each cell tower. So a phone, if it is in the location of a cell tower, could be within 37.7 square miles, which is a lot of ground. And most importantly, a phone doesn't always connect to the nearest cell tower. It connects to a cell tower based on an algorithm of location and strength of the signal, so it can't be interpreted as GPS data.
So can we reasonably infer that Ms. Becker was even at Mr. Brackman's home the day of the murder?
No, and even if you take my previous considerations into mind, you still can't infer that Avery Becker was there simply because her cell phone was within 37.7 square miles.
All right, and so moving along to the crime scene itself, could you explain a little bit about Ms. Kuzak's versions of events at that crime scene?
Yes, so for the wound, the wound sustained by Mr. Brackman to be the way it was, with the downward force towards the aorta, the perpetrator would have had to have been bigger than Mr. Brackman and also exert significant force, which doesn't seem likely if you look at the build of the intruder on the Ring video. It seems far more likely to me that the intruder snuck up on Mr. Brackman and stabbed him once with that significant force.
And so what would that mean for the case?
Well, an intruder coming into the home, sneaking up on Mr. Brackman and stabbing him once unaware would mean that they entered the home with the premeditation to commit this murder.
And do you believe that this murder was in fact premeditated?
Yes, I do. And looking at Avery Becker, a high school girl, it's clear that she doesn't have the motive over a high school extracurricular to commit this premeditated murder.
Did you find anybody?
Objection, Your Honor. The witness cannot testify to motive. Additionally, this all goes to ultimate issue.
Your response, Mr. Royal?
Your Honor, Professor Van Owen is simply testifying as to her opinions on the case, and as well as the suspects in the case and who may or may not have been more likely to commit the crimes in question.
Anything further, Ms. Verlinko?
I stand by my objection, Your Honor.
Objection sustained.
All right, so Professor Van Owen, did you find any other suspects in your investigation?
Yes, I found a suspect with a stronger motive, Blair Rollins.
And why was Blair important to the case?
Blair Rollins' father had been convicted of murder and sent to jail and Mr. Brackman was his defense attorney. Seeing your father carted off to jail seems to me that it's a much stronger reason to kill someone than a high school club.
And so as a result of finding Blair Rollins and his backstory, did you look further into him as a suspect?
Yes, I did. I looked into Blair Rollins, which is something that the police miserably failed to do. And I found that Blair Rollins was both absent from school on the day of the murder with no one to testify to his alibi, and furthermore is the same height and build as Avery Becker. So it could have just as easily been him on that Ring video.
And where is Blair now?
He's disappeared. No one knows where he is.
All right, so taking everything into consideration, would you say that the defendant was the perpetrator in this case?
No, my expert conclusion is that there is no reasonable way to come to the conclusion that Avery Becker was the perpetrator. The police heard hooves, and instead of thinking horses, Blair Rollins, the reasonable conclusion, they thought Avery Becker, zebras, completely unreasonable.
Thank you, Your Honor. No further questions at this time.
Cross-examination.
Yes, Your Honor. At this time, I would like to request a brief time check.
You have 19 minutes and 7 seconds.
You can proceed.
Now, Professor Van Owen, I'm going to ask you some questions about your job. You've consulted on over 100 cases, correct?
Yes, that's correct.
And you've testified on behalf of the defense every single time.
Well, the reason for that is that the prosecution tends to hire its own personnel, so a police detective or a police officer, while the defense is the one who typically hires me.
Ms. Van Owen, you're not answering my question. Have you testified on behalf of the defense every single time?
Yes, they're the ones that hired me.
Isn't it true that you've been paid thousands of dollars to consult on more than 100 cases exclusively against the police?
Your Honor.
Well,
Go ahead, Ms. Arroyo. I didn't hear you.
Oh, sorry. I objected to relevance.
Your response, Ms. Relenko, am I saying that right?
No, it's Rachlenka, but it's totally fine. Your
Sorry.
Honor, this is, Your Honor, this is absolutely relevant as this can show the bias of the witness, which is pertinent to her testimony today.
I agree. The objection's overruled.
So I'll restate my question. You've consulted on over 100 cases, paid thousands of dollars exclusively against the police, true?
Well, this is my job and I am paid for it, so yes.
And in every one of those cases, it's been your opinion that the police have dropped the ball, true?
Well, each case I come out with a fresh perspective and look at the evidence in it and of itself.
You didn't answer my question. So in every one of those cases, it's been your opinion the police have dropped the ball, true?
Well, I've testified on the defense every time, so yes.
Now I'm going to ask you some questions about the nature of your analysis. You were never at the crime scene, correct?
No, but I reviewed all the evidence found.
So until Miss Becker was charged, you did not see anything, did you?
No, yes, but I reviewed all the evidence previous.
So it's your testimony today that you saw evidence before Miss Becker was charged?
No, I saw the evidence after she was charged, but I saw the evidence that was collected previous to her being charged.
However, you did show up at trial today to criticize what the police did. True?
Well, my expert conclusion is that they rushed the case, so yes.
Now let's discuss the knife. Miss Van Owen, you believe that the most likely scenario is that the intruder brought the knife into the struggle. Isn't that true?
Yes, that's correct.
You further believe the state's theory that the knife came from the kitchen knife block is wrong, correct?
Well, the murder weapon didn't match the brand that was consistent in the knife block, so correct.
You certainly agree that there was an empty knife slot of the size of the murder weapon in the knife block, true?
Yes, but the rest of the knives didn't match the brand of the murder weapon.
I heard my answer. Isn't it true there was no physical evidence at all that the knife came from outside the home?
Oh, well, only that the knife was a different weapon, and that's considerable evidence.
And in the ring videos, there is no knife visible, correct? Miss Van Owen?
Looks like Ms. Van Owen may have frozen.
Yes, Your Honor. She just messaged me that her connection is spotty, and here she is.
Hello, sorry, I cut out. Apologies for that.
Alrighty, Miss Van Owen, in the ring videos, there is no knife visible, correct?
No, but the intruder was wearing heavy clothing.
Thank you. Additionally, isn't it correct there was an open knife drawer in the kitchen?
That's correct.
And there were a multitude of sizes and brands of knives within that drawer, true?
That's correct.
Now let's discuss the alternate suspect you mentioned, Blair Rollins. Just by looking at a yearbook photo, you came to the conclusion that Becker and Rollins were of the same build, correct?
Yes, and that means it could have been Blair Rollins in the ring video.
Did you do an analysis of every other classmate of Avery Becker with respect to size and build? Miss Van Owen?
Sorry, can you repeat the question? You cut out.
Did you do an analysis of every other classmate of Avery Becker with respect to size and build?
No, but I believe that Blair Rollins.
Isn't it true that you claim a more reasonable suspect than Blair Rollins?
Yes, Blair Rollins is more reasonable because his father went to jail for life.
You heard the recording from the hearing of his father, Jonathan Rollins, correct?
Yes, and his father yelled out threats against Mr. Brackman.
Now, Jonathan Rollins speaks in this recording, true?
That's correct.
Isn't it true you have no information that Blair Rollins in any way threatened Mr. Brackman at any time?
No, but he heard his father
Thank you.
threaten.
I heard it now. Your suspicion is based solely on the relationship between Blair Rollins and his father, true?
Yes.
So following this logic, the children of all of Mr. Brackman's clients who have been convicted should be suspects?
Well, I don't know about any other children besides Blair Rollins.
Now let's talk about the investigation. You claim that Detective Markowitz should have looked into additional suspects, correct?
That's correct. They didn't look into Blair Rollins.
Did you conduct an extensive search in an attempt to locate Rollins?
Yes, he's disappeared.
So you accuse of Detective Markowitz of not gathering enough cell tower evidence, true?
That's correct.
You believe he should have gathered Miss Perkins' data, true?
Yes, that's correct.
You believe Detective Markowitz should have gathered Blair Rollins' data, correct?
Exactly, yes.
However, you didn't gather that evidence yourself, did you?
Well, I only conducted a partial investigation, so no.
You're not answering my question, Ms. Van Owen. Did you gather that evidence?
No, I only conducted a partial investigation.
Thank you. So additionally, you accused Detective Markowitz of making assumptions about the status of Mr. Brackman's ring notifications, correct?
Yes, that's correct.
However, you didn't check the status of those notifications yourself, did you?
No, like I said, I only conducted a
So
partial
you did not collect evidence to prove that the prosecution's accusation of Ms. Becker is false, correct?
Well, all my evidence leads me to believe that Miss Becker is not the
Ms. Van Owen, that's not the question I asked. You did not collect additional evidence to prove the prosecution's case was false, correct?
No, I did collect evidence.
Meanwhile, the evidence you collected was an extensive search to validate your own conclusion. True?
Well, the evidence led me to my conclusion, not the other way around.
And this evidence that you gathered yourself was about Mr. Rollins. True?
Exactly, yes.
Thank you, Your Honor. No further questions.
Any redirect?
Very briefly, Your Honor.
Go ahead.
So, Professor Van Owen, why did you look into Blair Rollins specifically and no other of Avery's classmates?
Blair Rollins' father had been represented by Mr. Brackman in a murder case, and he had been found guilty. And Blair was at the sentencing when his father was carted off to jail. That's significant motive. Furthermore, no one can testify to his alibi on the day of the murder, and he's disappeared.
Thank you, Your Honor. No further questions.
Anything further for this witness?
No, Your Honor.
No, Your Honor.
Okay, the witness is excused. Next witness.
The defense calls Taylor Perkins to the stand.
Okay, you may proceed when you're ready.
Good afternoon. Please introduce yourself to the jury.
Good afternoon. My name is Taylor Perkins.
How do you know the defendant and the victim in today's case?
I know the defendant, Avery Becker, because we're best friends and we're on the mock trial team together for 4 years at Colorado High School. And I know the victim, Mr. Brackman, because he was our coach for those 4 years.
Could you briefly explain to the jury what mock trial is?
Of course. Mock trial is an activity where our team is given a case to prepare for trial. So we spend lots of time together preparing for competition and then go against other schools.
What was your relationship with Avery Becker like?
Avery and I were best friends. She was actually the reason I joined mock trial in the first place back in freshman year. And we've been on the team together ever since, and it was a really good experience.
How was she as a team member?
Honestly, Avery was the most talented lawyer on the mock trial team. She had this incredible gift for making things up on the fly and was just a really natural lawyer, and I really enjoyed watching her compete.
Did she and Mr. Brackman get along?
Well, Mr. Brackman and Avery definitely had their differences. They had incredibly different approaches to mock trial, and that led to some conflict because Avery tended to be more instinctual, whereas Coach Brackman expected preparation and hard work.
Could you give an example of one of these disagreements?
Well, when competitions arose, their disagreements usually got more heated, and once Avery was demoted from the A team to the B team.
How did you respond to this demotion?
After Avery was demoted, mock trial really wasn't worth doing without her. So I ended up stepping down for Avery's sake and the team's sake because the team needed her to succeed.
Was Avery able to compete at the regional tournament?
Yes, Avery competed at regionals, and the whole team did very well because of her. Avery won 2 awards, Best Attorney and Best Closing. So I stand by my decision to step down.
What happened after this tournament?
After this tournament, Brackman was still upset with Avery.
Objection, Your Honor, speculation. The witness cannot testify to how Mr. Brackman felt.
Your response, Mr. Zeichus? Zeichus, thank you.
Very close though. Mr. Perkins does have the personal knowledge as he's a member of the mock trial team and he's best friends with Avery Becker.
Why don't you lay a little bit more foundation with this witness as to what his personal knowledge is or his observations of the coach?
Did anything happen after the mock trial tournament in regards to Avery's position on the team?
Yes. Mr. Brackman got very upset with Avery and was still not pleased with her performance, even after she won those awards. So after yelling at Avery, Avery stormed out and, in what she thought was dry erase marker, wrote—
Objection, Your Honor, lack of foundation.
Your response, Mr. Zeichus. Say it again.
Zeichus.
Zeichus.
Rhymes with righteous.
Easy, thank you. Zeichus, your response.
I'm sorry, could you remind me of the objection?
Will you restate it, Ms. Gebhardt?
Yes, Your Honor, lack of foundation as the witness has not testified to how he knows this knowledge.
About the marker?
About the entire incident.
Okay.
In question.
And your response, Mr. Zeichus?
Your Honor, once again, the witness is best friends with Avery Becker and is a team member of the mock trial team, and therefore he would know about an event as important as this one, and it's rationally based upon his perception.
Was he there?
No, Your Honor.
Okay. I'm going to sustain the objection.
After getting kicked off the mock trial team, did Avery try to rejoin?
Yes, and I helped Avery with that. She reached out to everyone on the team and tried to talk to Mr. Brackman herself.
Did she meet any of the team members in person after being kicked off?
Yes. After she went and tried to talk to Coach Brackman, together we went to Fry Shack for dinner, and there we ran into the entire mock trial team.
How did Avery respond to seeing members of the mock trial team?
Well, naturally, Avery got pretty upset because it was a team she cared so much about and regretted what she did so much, so she naturally got pretty upset because she knew she couldn't be part of it anymore.
Were you and Avery together at the Fry Shack the whole time?
We were, except at one time she did leave to go to the bathroom, leaving her phone on the table with Alex Cifuentes and I.
Now let's talk about some other students at Colorado High School. Did the students there generally get along with Mr. Brackman?
Yes, everyone on the mock trial team loved Mr. Brackman, but there was one other student who had a history with him.
Who was this student?
This student was Blair Rollins.
How did Blair Rollins know Mr. Brackman?
Mr. Brackman was actually the lawyer that lost the case that sent Rollins' dad to prison, and Blair resented Mr. Brackman for that.
Do you know where Blair Rollins was on the day of the murder?
I don't know where he was, but I know where he wasn't, and he wasn't at school that day.
Now let's talk about the day of the murder. Where were you on March 6th?
On March 6th, I was with Avery the entire day.
What did you two do together?
Well, that morning, Avery picked me up to drive to school, and together we realized Avery had lost her phone, so we decided to skip school that day to look for it.
Where all did you look for this phone?
We retraced all of our steps from the day before, so we looked all over the mall and visited the Fry Shack twice.
Did you see anybody at the Fry Shack?
Yes, in the afternoon we ran into some of the mock trial kids who weren't at practice. That was because Mr. Brackman didn't show, and it's just so sad to think none of us would ever see him again.
On March 6th, could Avery Becker have killed Mr. Brackman?
Absolutely not. First of all, Avery and I were together the entire day, from morning to night. And secondly, Avery cared about mock trial and Mr. Brackman and would never commit murder.
And finally, did you ever find Avery Becker's phone?
No, after searching the entire day of March 6th, we didn't find it. And the last place I remember seeing it was on the table with Alex Cifuentes.
Thank you. No further questions at this time.
Cross-examination?
Yes, Your Honor. Good afternoon, Mr. Perkins. I would like to begin by asking a few questions about your mock trial team. Isn't it true that you thought Mr. Brackman was a mediocre coach?
Yes, he could be at times.
You also thought he made bad choices for the team, correct?
Yes, that's correct.
Miss Becker drove Mr. Brackman crazy, correct?
They tended to get on each other's nerves, yes, because of their differences.
Isn't it true that their little feud bothered Miss Becker?
Well, naturally, because Avery was so gifted, but Mr. Brackman just didn't acknowledge that.
It bothered Miss Becker enough to play some pranks on Mr. Brackman, correct?
Yes, that's correct.
Now, on to the subject of one of those pranks, the car incident. Isn't it true that you heard about the practice in which the car was vandalized from Miss Becker?
Objection, hearsay.
Response, Your Honor?
Your response, yes.
Your Honor, pursuant to Rule 801D2, this is not hearsay as it is a statement of a party opponent.
Anything further, Mr. Zeichis?
No response, Your Honor.
The objection's overruled.
I will re-ask my question. Isn't it true that you heard about the practice in which Mr. Brackman's car was vandalized by Miss Becker from Miss Becker?
Yes, we spoke after the incident.
Isn't it true that Miss Becker wrote on Mr. Brackman's car?
Yes, in what she thought was dry erase marker.
She wrote Worst Attorney Award, correct?
Yes, that's correct.
And Miss Becker wrote this in permanent marker, ruining the paint on the car, correct?
That is what ended up happening, but as I said before, it was an accident in permanent marker.
Isn't it true that Miss Becker was then kicked off the team?
Yes.
After she was kicked off the team, the two of you discussed ways she could get back on, correct?
Yes, that's correct.
Isn't it true that she then texted everyone on the team?
Yeah, she reached out to all of her team members in support.
And isn't it true that Miss Cifuentes is a member of that team?
Yes, that's correct.
Now, back to the subject of Miss Becker. You and Miss Becker were best friends, correct?
Yes.
You even quit something you were pretty good at in support of Miss Becker, yes?
In part in support of her, yes, but also in support of the team and for my own sake.
Isn't it true that you and Miss Becker realized that she was missing her phone on the morning of March 6th?
Yes, that's correct. When she picked me up for school, we realized.
Isn't it true that you first went to the mall and checked each store you had gone to the day before?
We did, retracing our steps.
You then went and checked at the Fry Shack, correct?
Yes, that's correct.
Miss Becker's phone was like Miss Becker's third kidney, never out of reach, correct?
That's correct, and that's why I remember her leaving it at the table.
Thank you. And yet, she didn't notice its absence until the next day?
Yes, because we realized she hadn't been responding to my texts.
All the way home from the Fry Shack, she didn't notice it was missing?
Yes, but I think her emotions were a little bit going because she saw
Thank
her.
you. For the rest of the evening, she didn't notice it was missing.
No, but as I was saying, she was upset about seeing the team at the Fry Shack.
Thank you. No further questions.
Any redirect?
No need, Your Honor.
All right, this witness can be excused. Any further witnesses for the defense?
Yes, Your Honor. The defense calls Miss Avery Becker to the stand.
Okay, you may proceed when you're ready.
Hi, Ms. Becker. Could you please introduce yourself to the jury?
My name is Avery Becker.
Tell us a little bit about yourself.
Yeah, I recently graduated from Colorado High School, and one of the main things I did was mock trial.
Let's talk a little bit about that mock trial team. What was your experience with mock trial?
Mock trial was great. Just thinking about it right now, I loved it because you could be competitive, but also in a social atmosphere, and that's hard to come by in a high school activity.
How invested were you in this club?
Invested enough to win a couple of awards, and our team qualified for state. I loved mock. It just came naturally to me.
Let's talk a little bit about your mock trial season. Did you do any tournaments last year?
Yes, regionals, and we were going to go to state.
What can you tell us about that regional tournament?
Like I said, it went really well. Our whole team was proud of ourselves. I actually won Best Attorney Award and was named the best closer.
Before I move on to talking about that, I'd like to mention your relationship with your mock trial coach, Mr. Brackman. How was your relationship with Mr. Brackman?
I'm sure anyone who's done mock trial can understand. He was our coach. He helped our team prepare, but he was also a lawyer. We had our disagreements.
What do you mean by that?
Well, he always wanted a perfectly memorized script, and I wanted a competitive performance. Those often clashed.
So, as we're talking about it in the context of your regional tournament, how did Mr. Brackman react to your doing so well at regionals?
He was anything but pleased.
How did you know that?
We had a falling out at the practice after regionals.
And what happened then?
He was upset with my performance. He was mad. I was mad. He was hurt. I was hurt. I stormed out. I wrote on his car. I thought it was a erasable marker. And, it was a weird situation. He even came out to apologize to me. Of course, he
Objection,
saw
Your Honor.
the car and
Objection, Your
Hold
Honor.
on, there's an objection. What's your objection, Miss Wu?
Your Honor, I was objecting, the witness was outside the scope of the question.
Your response, Miss Leland?
Your Honor, I asked this witness what happened at the given situation we're talking about, which is the car incident, I guess you could call it. She's merely describing the sequence of events that happened in that situation.
Objections overruled. You may proceed.
So, Ms. Becker, what happened when Mr. Brackman came outside?
yeah, so he was coming out and initially was going to apologize. He saw what happened to the car and I was kicked off the team, but it was really weird how the whole situation, went out. It was like a way of us putting all of our cards out on the table and saying, I'm done with just the superficiality of our relationship and just ready to move on. It was a tipping point to then reconcile with each other and reconcile our differences. It was my senior year. I wanted to end on a good note.
Objection, Your Honor. The witness is outside the scope of the question.
Miss Leland?
Your Honor, my witness was finished. We can move on.
Okay, move on then.
What happened after this incident?
Yeah, after going home, talking it over with my mom, just processing my emotions and how I was feeling, I knew I had to apologize to him in the best way possible.
So did you apologize to Mr. Brackman?
Yes, the next day I went to his office to apologize to him in person and have a conversation, but he didn't want to speak. So I just sent him text messages telling him how sorry I was, how I thought it was erasable. I would do anything, get a job to get his car repainted, not only to repair our relationship, but to repair my relationship with the team and help the team at state.
Now, I would like to talk a little bit about March 6th, 2020. What were you doing that day?
I was with Taylor.
What were the two of you doing?
We were looking for my phone, which I didn't know where it was.
And were you with Mr. Perkins the whole day?
Yeah.
When had you last seen your phone?
If I knew where I'd last seen it, I would have it in my hands right now, but my last memory of it was at the fry shack the night before.
Did you at any point during that day go to Mr. Brackman's house or near Mr. Brackman's house?
No, I don't know where he lives, and regardless of that, he didn't want to speak in person. He hadn't responded to my text messages. He wasn't ready, and I wish he knew how sorry I was. Really do.
And finally, Miss Becker, did you kill Mr. Brackman?
No. That's just no.
No further questions at this time, Your Honor.
Cross-examination?
Yes, Your Honor. Now, Ms. Becker, Ms. Becker, I'm going to start by asking some questions about your performance in mock trial. You were on the mock trial team, correct?
Since freshman year.
And you competed in mock trial competitions, correct?
Yes, with everybody on the team.
And you even obtained some Best Attorney awards, correct?
Yes, I was proud of not only the awards I won, but also just how well our team could perform.
And the scoring judges were like putty in your hands, correct?
Scoring judges, it can be random at points, but also just the way you communicate with people.
Ms. Becker, that was not the question I asked. The question I asked was, isn't it true that the scoring judges were like putty?
Objection, Your Honor. Improper character evidence.
Your response, Ms. Wu?
Your Honor, this is not improper character evidence, as I'm not trying to elicit a response from the defendant in which to prove a character for truthfulness or untruthfulness.
Overruled. Go ahead.
And isn't it true the scoring judges were like putty in your hands?
I can't speak for how the scoring judges felt, but I was proud of the performances I would give at regionals.
Ms. Becker, that was not the question I asked you. Isn't it true that the scoring judges were like putty in your hands?
Like I said, I was proud of my performances and proud of how they were scored.
Ms. Becker, this is a yes or no question. Isn't it true that the scoring judges were like putty in your hands?
I was proud of my performance. Yes, I was proud of my.
I'm going to move on to asking some questions about your relationship with the deceased, Mr. Brackman. Isn't it true that Mr. Brackman was your mock trial coach?
Yes.
And you and Mr. Brackman didn't get along, correct?
We had different approaches to the team, and it often got in the way of our relationship.
And isn't it true that Mr. Brackman said you were lazy?
He perceived that, the way I showed up to practice, the way I wanted to be there for the team.
That was not the question I asked you. Isn't it true that Mr. Brackman said you were lazy?
Objection, Your Honor. Hearsay.
Your response, Ms. Wu?
Yes, Your Honor. This question is not by definition hearsay, as it is not offered for the truth of the matter asserted. It is offered to show the relationship between the defendant and Mr. Brackman.
Any response, Ms. Leland?
Yes, Your Honor. The nature of the relationship between the two parties in this case depends directly on the context, on the content of these statements, and therefore are statements being offered for the truth of the matter asserted.
Your Honor, may I
overrule do you have something further, Ms. Wu?
Yes, Your Honor. Yes, Your Honor. The truth of the matter asserted in that question was that the defendant would be lazy. However, I'm not offering it to prove that the defendant is lazy. I'm offering it to show the relationship between the defendant and Mr. Brackman.
The objection is overruled. You may proceed.
Ms. Becker, this is a yes or no question. Isn't it true that Mr. Brackman said you were lazy?
In a moment, and again, it was just how he perceived how I wanted to.
Ms. Becker, is this a yes or is this a no?
There for the team.
Ms. Becker, this is a yes or no question.
Yes, there's so much more to that as well.
Ms. Becker, I'm going to ask you some questions about the mock trial practice after regionals. At that practice, you were angry at Mr. Brackman, correct?
A lot more than angry. There's a lot of emotions involved. I was hurt,
Ms.
confused.
Becker, my question was whether or not you felt other emotions. You were angry at Mr. Brackman, correct?
You can't categorize it as just anger. I was ashamed that he didn't.
Ms. Becker, again, this is not the question that I asked you. Your Honor, could you please direct the witness to answer my question?
Yeah.
I think the witness has answered your question. You can move on, Ms. Wu.
Yes, Your Honor. And afterwards, you called Mr. Brackman the worst coach in the state, correct?
It was a heated moment for the both of us. We were hurt. It was just miscommunication.
But Ms. Becker, you did call Mr. Brackman the worst coach in the state, correct?
While we were both hurt by what each other had said to one another.
And afterwards, you stormed out of practice, correct?
I just wanted him to understand me and understand where I was coming from.
And you had a permanent marker in your hand, correct?
I didn't know it was a permanent marker.
But Ms. Becker, it was a permanent marker, correct?
Objection, Your Honor, relevance.
Your response, Ms. Wu?
Your Honor, the fact that the defendant had a permanent marker in her hand is directly relevant to the extent of what Ms. Becker did.
Your Honor, if I may respond.
Go ahead.
The witness just testified that she did not know she was holding a permanent marker. Thus, any probative value of determining whether or not it was a permanent marker in terms of her motive or intent is irrelevant because she didn't know either way.
I'm going to allow it. The objection's overruled.
And you stormed out of practice with a permanent marker in your hand, correct?
I didn't know it was permanent, and I thought it would have just erased and we could talk. I didn't know it was permanent.
This was not the question
After I found out it was permanent, I told him I would do anything to get it fixed, get his car fixed, get a relationship.
Ms. Becker, again, that was not the question that I asked you. You had a permanent marker in your hand, correct?
Yes, I didn't know it was a permanent marker.
And you saw Mr. Brackman's obnoxious white car, correct?
It was, a moment of frustration and confusion and just, why can't he understand me? I was.
My question was not about how you are feeling right now. My question was that you saw Mr. Brackman's obnoxious white car, correct?
Objection, Your Honor. Counsel is testifying. She's assuming that this car was obnoxious, which is not just her testifying.
Your response, Ms. Wu?
Your Honor, this is not testimony that I have been making. This is testimony that is available in the defendant's affidavit.
Overruled. The defendant will answer, the witness will answer.
Ms. Becker, this is a yes or no question. You saw Mr. Brackman's obnoxious white car, correct?
No matter if I thought it was obnoxious or not, that wouldn't, affect.
Ms. Becker, my question was whether or not if you thought it was obnoxious. You saw Mr. Brackman's obnoxious white car, correct?
I saw his car.
And you vandalized Mr. Brackman's car, correct?
It was just a moment of.
Ms. Becker, the question was. Ms. Becker.
I was ashamed. I was hurt. I was confused.
Your Honor, we have a limited amount of time for cross-examination in which the witness is purposefully filibustering. As such, I would like you to direct the witness to answer my questions.
Ms. Becker, please try to answer the questions. If you can answer them with a yes or no, please do so. Your counsel will have an opportunity for any follow-up questions that may be needed. Go ahead.
Understood.
Ms. Becker, this is a yes or no question. You vandalized Mr. Brackman's car, correct?
I thought it was an erasable marker. Vandalism is permanent, and I didn't know it was going to be permanent.
Yet you did vandalize Mr. Brackman's car, correct?
Regretfully and shamefully.
Thank you. I heard a yes. And you wrote Worst Attorney Award across the hood of that car, correct?
And I just hoped that we could have talked about it. And
Becker, the question I asked was not about what you were feeling. My question was, you wrote worst attorney award, correct?
emotions back all actions, and I just wanted to be understood by Mr. Brackman.
Yet you wrote worst attorney award with that permanent marker, correct?
Thinking I could have just erased it.
Yet you did write worst attorney award, correct? A simple yes or no will suffice.
As you've said previously. Yeah.
And you stood there afterwards, thinking how what you had done would show Mr. Brackman what you really thought of him, correct?
It wasn't anger, it was just this confusion of...
Ms. Becker, a simple yes or no will suffice. You stood there afterwards, thinking how what you had done would show Mr. Brackman what you really thought about him, correct?
He'd been our coach for years, and I just wanted to be understood by him. It was my senior year, time to
move on.
Reconcile.
And afterwards, Mr. Brackman started to apologize to you, correct?
Yeah, and then, he saw the car.
I heard a yes. And after he saw what you had done to his car, Mr. Brackman kicked you off the team, correct?
Yeah, and I understand
Thank you. I heard a yes. And that made you even madder, correct? Ms. Becker, this is a simple yes or no question.
I was hurt. I was confused. I just wanted him to understand me. So,
Ms. Becker,
much more than that. It wasn't just anger. It was
Ms. Becker, the question I asked was that after you kicked off from the mock trial team, that made you even madder, correct?
No, I went home. I talked through my emotions.
Ms. Becker, is it your testimony today that you were not even madder after Mr. Brackman kicked you off the team?
I was madder. I was more confused.
Thank you. I heard a yes to that question.
I was lost.
Ms. Becker, thank you. I heard a yes to that question. And afterwards, you told your mother that you would get back at Mr. Brackman if it was the last thing you did, correct?
Those are private conversations with my mom, who is, I look up to her. She guides me. So it's
Ms. Becker, that was not the question I asked you.
Confiding in someone and understanding how I feel, how I knew how to apologize.
That was not the question that I asked you. A simple yes or no will suffice. You told your mother that you would get back at Mr. Brackman if it was the last thing you did, correct?
While in conversation of just understanding where I wanted my relationship with Mr. Brackman to be and just where we understood each other.
Ms. Becker, Your Honor?
Yes or no, Ms. Becker? It's a yes or no question.
Ms. Becker, you told your mother that Ms. Becker, you told your mother that you would get back at Mr. Brackman if it was the last thing you did, correct?
Yes.
Thank you, Your Honor. No further questions.
Any redirect?
Yes, Your Honor.
Go ahead.
Hi, Ms. Becker. I would like to talk a little bit more about this car incident, I guess we're calling it. What did you think of Mr. Brackman after this incident?
I felt terrible about the whole situation. It was just a moment of, putting all of our cards out on the table, and I just wanted him to understand me, but I also was ready to let go of my ego and have me understand him.
And how did you feel after this whole situation happened?
I felt hurt, ashamed, angry, confused.
And how do you feel now?
I don't know. I don't know how I feel. I'm just trying to tell my truth up here because the truth is the only thing that can save me.
No further questions, Your Honor.
Anything further for this witness?
No, Your Honor.
Does the defense have any other witnesses to present?
No, Your Honor. At this time, the defense rests.
Okay, is the prosecution ready for closing argument?
Yes, Your Honor. Before I begin, I would just like to re-ask that all remaining time be reserved for rebuttal.
It will be reserved. Thank you. You may
Thank you,
proceed.
Your Honor. May it please the court?
Whenever you're ready.
Your Honor, members of the jury, we told you at the beginning of this trial that this is a case about bitterness turned brutal. We have a bitter young woman and a brutal murder. Now, in her opening statement, my co-counsel, Ms. Wu, told you that today the state would prove beyond a reasonable doubt each and every element of both crimes with which the defendant is charged, thus meeting the burden of proof which lies with the prosecution in this case. Now, a number of these elements are undisputed, that this crime occurred in the state of Colorado on March 6, 2020, and that Mr. Brackman is now dead. The issue in this case is whether or not the defendant's bitterness led her to break into Mackenzie Brackman's home and in the process brutally murder her own coach. The evidence presented by the state today showed that this is exactly what happened. First, we proved who committed this crime. You heard the testimony of Detective Jordan Markowitz, who described the crime scene in detail. Detective Markowitz testified to seeing the body lying in a pool of blood with blood splatter all the way up the wall and even on the ceiling. Detective Markowitz also testified to seeing the knife used as a murder weapon covered in blood, and to collecting videos which show a perpetrator entering the side of Mr. Brackman's home. Detective Markowitz testified to reviewing messages from the defendant in which she stated that she was going to break into Mr. Brackman's home and trash it. And finally, Detective Markowitz testified that in her expert opinion, she was able to place the defendant through cell tower data near the victim's home at the time the crime took place. Now, what happened? Today, you also heard from Kyle Kuzak, an expert crime scene reconstructionist. Ms. Kuzak testified that in her expert opinion, this was clearly a case of a planned burglary gone bad that resulted in the brutal death of Mr. Brackman. Ms. Kuzak also testified that in her expert opinion, the sequence of events happened as follows. Mr. Brackman was alerted to the presence of an intruder by his Ring doorbell notifications. As the intruder entered his home, he frantically searched for a knife, grabbing the biggest knife he could find from the knife block in his own kitchen. When the intruder then entered the home, the two fought over that same knife. And then the intruder was able to take that knife from Mr. Brackman and stab him with it above his left shoulder, leaving him to die at his own front door. Now, why the defendant did it? Today, you heard from mock trial team member Alex Cifuentes. Ms. Cifuentes testified to the defendant's increasingly aggressive behavior toward Mr. Brackman over the course of the season. Ms. Cifuentes testified about countless arguments between the defendant and Mr. Brackman, and with one such argument even escalated to the point of the defendant vandalizing Mr. Brackman's car and writing worst attorney award on it. After this incident, the defendant was then kicked off the team, and that's when her bitterness boiled over. The defendant texted Alex Cifuentes and told her that she was going to break into Mr. Brackman's home and trash it. The defendant did exactly what she said she was going to do. She just didn't plan on Mr. Brackman being home. But when Mr. Brackman was home, the defendant took it from breaking in to brutal murder. Today, the defendant demonstrated her pattern for impulsive and bitter acts. After being kicked off the mock trial team, the defendant even stated that she would get back at Mr. Brackman if it was the last thing she did. Your duty as jurors is to evaluate the evidence, and the evidence presented today shows the defendant committed this crime. Accordingly, the prosecution has proven each and every element beyond a reasonable doubt, thus meeting the burden of proof. As such, the state asks you to find the defendant guilty of murder in the first degree and second-degree burglary.
Thank you, Ms. Gebhardt. Closing argument from the defense.
Yes, Your Honor.
You can proceed whenever you're ready.
Heard hooves, and thought, zebras. The police heard man convicted of murder on Mr. Brackman's watch and thought killed over a high school club. The investigators heard stabbing and thought acrobatic knife wielding. The prosecution heard Blair Rollins and thought Avery Becker. Blair Rollins likely killed Mr. Mackenzie Brackman. As you heard today, Blair Rollins' father was represented at his murder trial by Mr. Brackman and was found guilty. So Blair Rollins watched as his father was carted off to jail and the person standing right next to him when it happened, the person he and his father blamed, was Mr. Brackman. Blair Rollins thought that Mr. Brackman had stabbed him in the back. So he decided to do the same to Mr. Brackman. On March 6th, 2020, Blair Rollins took the day off school, found a disguise and a knife, and headed to Mr. Brackman's home. As you heard today, he went around back, snuck up behind Mr. Brackman whilst he was seated at his dining table and stabbed Mr. Brackman in the back. This story makes sense. Mr. Brackman wasn't killed because some high school kid was upset about their high school extracurricular. He was killed because he failed to protect a kid's father, failed to keep him out of jail. Mr. Brackman wasn't killed in the midst of some knife fight where the defendant somehow managed to maneuver the knife out of Mr. Brackman's hand without sustaining a single cut on her body, a knife fight that supposedly ended with Miss Becker trapping Mr. Brackman, trapping Miss Becker in a bear hug and stabbing him through the shoulder. No, he was killed by a person that snuck up behind him, a person that wanted to kill him. But Blair Rollins is not on trial today because the prosecution jumped to conclusions and only considered one angle of this case. We are here today because the prosecution heard hooves and thought zebras. Not only did the prosecution fail to investigate the possibility of Blair Rollins' involvement, they also failed to provide conclusive evidence of Miss Becker's involvement. As you heard from their crime scene reconstruction expert today, she couldn't say what happened at the crime scene because she wasn't there. She couldn't tell you what happened. She couldn't tell you how the situation went down, but she could tell you that she jumped to conclusions about it, that she somehow deemed that Miss Becker was guilty. You also heard that the key piece of evidence linking Miss Becker to this crime is a screenshot of a supposed text message thread sent from Alex Cifuentes, one of Miss Becker's jealous peers on the mock trial team. And these messages were not authenticated in any way. You also heard the prosecution try to prove Miss Becker's whereabouts using cell tower data, but again, this data has no real meaning today because cell tower data cannot be accurately used for this purpose. You also heard from Taylor Perkins, Alex Cifuentes, and Miss Becker that Miss Becker spent the whole day with Taylor Perkins, never went near Mr. Brackman's house, and spent time with several other people at the Fry Shack who could corroborate her whereabouts for a significant portion of the day. Miss Becker simply was not at Mr. Brackman's home. The prosecution held the burden of proof in today's case, and that was the burden of reasonable doubt. They had to prove to you each element of this case beyond a reasonable doubt. And a reasonable doubt is a doubt that arises from the fair and rational consideration of all of the evidence or lack of evidence in a case. They could not prove this burden. They could not meet this burden. They could not prove that Miss Becker had intent to commit criminal mischief. They could not prove that Miss Becker committed second-degree burglary, and they certainly could not prove that Miss Becker killed Mr. Brackman. Now, we, the defense, had no burden to prove anything at all today, but we still brought you substantial evidence pointing towards Blair Rollins' involvement in this crime. If you think that even the possibility of Blair Rollins' involvement in today's case creates reasonable doubt on the prosecution theory, you should not convict Avery Becker of this crime. At the close of this trial, we ask you to consider all of the evidence pointing to Blair Rollins' involvement and the lack of evidence pointing to Avery Becker's involvement, and we ask that you don't hear hooves and think zebras. We ask you to submit a verdict of not guilty.
Thank you, Ms. Leland. I believe the prosecution has a little bit of time reserved. You may proceed when you're ready.
defense heard police investigation and immediately thought rushed. The defense heard Jonathan Rollins and immediately thought that Jonathan Rollins' child committed this murder. The defense heard Avery Becker and immediately thought Blair Rollins, despite the thorough investigation incriminating the defendant. Remember, this is a case about bitterness turned brutal. Find the defendant guilty.
If everybody wants to rejoin on the video.
Your Honor, before the trial concludes,
Yes.
I would like to raise a inside the bar dispute.
Okay.
Your Honor, I believe there was a violation of Rule 4.4 during the cross-examination of Blake Van Owen, in which the witness's Wi-Fi connection broke up. The directing attorney said she has just messaged me and held up what looked like a phone. This is a violation of Rule 4.4, as team members may not use any device capable of communication during trial except for the Zoom chat. And
I'm sorry, tell me again, Ms. Wu, what you recall the attorney in that situation relaying to the court after getting a text message from the witness. What is it you recall hearing?
Yes, she held up what looked like a phone. I'm not sure if it was, and said she has just messaged me.
Your Honor, may I respond?
Yes, absolutely.
I held up a pen. If I said text, I misspoke. I was communicating with Miss Bond through the Zoom features. I can send a screenshot of that chat if necessary.
No, dude, I was just clarifying.
Of course.
So it was a chat through Zoom that you got the message from the witness? Okay. Ms. Wu, is that representation acceptable to you?
Yes, Your Honor.
Okay. So do we need to do anything further with your?
No, Your Honor.
Inside the bar. Okay. Great. Where are our judges? Oh, you can come back now. Is everybody here? Let's see. Oh, maybe I'm only seeing the people on video. Okay, so I just want to say, great job, everybody. I think normally we do have an opportunity for some after chat, but I was told in the instructions that after the fourth round, we do not have an opportunity for after chat. So unfortunately, we aren't going to have the opportunity to have comments about, individual performances and things like that. So I would just say that everybody did a really, really great job. It was a pleasure to be involved in this case with you all today. Thank you all very much. Keep up the great work. This is a great experience, and you guys are all really on a good path to a great career in law if that's where you decide to go. So with that, unless anybody has anything else, I think we would conclude.
Is there another round after this?
From my knowledge, today's rounds are just the two. There's one. This is round 4.
Yes, Your Honor, this is the final round.
That's what I thought. So yeah, and for whatever reason, they don't allow any after chat after round 4. I confirmed it in between the breaks. So there you have it. If there's nothing else, then I guess you all go where you go, and I guess we go where we're not sure where we're going, but thank you all again.
Terrific.